Abaka ba Parliament abasimbiddwa mu kkooti y'obulyake n'obukenuzi okuggulwako emisango kwe kuli Owaigara East era ssentebe w'akakiiko akakwasisa empisa mu Patriotic League of Uganda Michael Mawanda, omubaka wa Busiki County Paul Akamba wamu n'omubaka wa Elgon County Ignatius Mudimi ko ne munnamateeka Julius Kirya Tayita Nkoko. Bano mu kkooti ne bagguddwako emisango 5 okubadde ogw'obulyakeko n'okubuzaabuza ensimbi ezaali ez'abantu abaakosebwa mu lutalo aba Buyaka Growers Cooperative Society mu disitulikiti y'e Bulambuli. Bano mu kkooti ne bagasimbaganye n'omulamuzi Joani Asiro era ng'omubaka Michael Mawanda agguddwako omusango gw'okubulankanya ensimbi akawumbi kamu wamu ne miliyoni 50 eza Uganda ezaali ez'okuwa abantu b'e Buyaka Growers Corporation mu disitulikiti y'e Bulambuli.
Your particulars, please be attentive. A1, Honorable Mawanda Michael Maranga, male adult, aged 56 years old, Munyankole by tribe, Honorable Member of Parliament representing Igara East constituency, and a resident of Kololo, Kampala district. A2, Honorable Wamakuyu Ignatius Mudimi, male adult, aged 54 years old, Emugishu by tribe, Honorable Member of Parliament representing Elgon County in Bulambuli district and a resident of plot 1936 in Nsambya Estates, Goodwill Zone, Machinje Division, Kampala City. A3, Honorable Akamba, a male adult, aged 41 years old, a Musoga by tribe, Honorable Member of Parliament representing Busiki County in Namutumba District and a resident of Chanja Central, Nakawa Division, Kampala City. F4, Kirya Julius Taitankoko, male adult, aged 50 years old, Emugwere by tribe, advocate at Kirya and company advocates, resident of Kauku Entebbe Road, Kajansi Town Council, Wakiso District. Statement of offense. Diversion of public resources contrary to Section 6 and 26 of the Anti-Corruption Act 2009 as amended. Statement of the offense. Honorable Mawanda Michael Maranga, in the month of October 2021 in Kampala, at Kampala District, converted public funds amounting to Uganda shillings 1,050,000,000 for purposes related to that for which the resources were intended, to wit, war loss compensation by the government of Uganda to Buyaka Growers Cooperative Society Limited for his own benefit. Honorable Mawanda, have you heard and understood? Is that true or it's not true?
Okusinziira ku ludda olwabeera kigambibwa nti omubaka wa Busiki County Paul Akamba yabuzaabuza ensimbi obukadde 2 ezaali ez'okuliyirira abantu bano.
Count 3, statement of offense. Diversion of public resources contrary to Sections 6 and 26 of the Anti-Corruption Act 2009 as amended. Particulars of the offense. Honorable Akamba Paul, between the months of May 2023 and June 2023, in Kampala at Kampala District, converted public funds amounting to Uganda shillings 200 million for purposes unrelated to that for which the resources were intended, to wit, war loss compensation by the to Buyaka Growers Cooperative Society Limited for his own benefit. Honorable Kamba had and understood. How do you plead? Amounting to Uganda shillings 2,228,714,611 for purposes unrelated to that for which the resources were intended, to wit, war loss compensations by the government of Uganda to Buyaka Growers Cooperative Society Limited for his own benefit. Mr. Kiria had and understood. Is it true or if not? A plea of not guilty is entered.
Ate ye mubaka wa Elgon County Ignatius Mudimi aguddwako omusango gwa kubba nsimbi obuwumbi 2 mu obukadde 390 nga munnamateeka Julius Kirya Taita Nkoko aguddwako omusango gumu ogw'obukadde obusoba mu 200.
Count 2. Statement of offence. Diversion of public resources contract section 6 and 26 of the Anti-Corruption Act 2009 as amended. Honorable Mudimi in Kampala at Kampala district converted public funds amounting to Uganda shillings 2,398,714,611 for purposes unrelated to that for which the resources were intended, to wit, war loss compensation by the government of Uganda to Buyaka Growers Cooperative Society Limited for his own benefit. Honorable Mudimi, have you heard and understood? How do you plead? A plea of not guilty is entered. Proud contract section 309 of the Penal Code Act, Cap 120, particulars of the offence. Honorable Mawanda Michael Maranga, Honorable Mudimi Wamakulu Ignatius, Honorable Akamba Paul, Kirya Julius, Kavundira Leonard, and others still at large between 2019 and 2023 conspired to defraud the government of Uganda shillings 3,448,714,611, which was intended for war loss compensation to Buyaka Growers Cooperative Society Limited. Honorable Mawanda, believing that you've heard and understood, how do you plead? Plea of not guilty is entered. Honorable Mudimi, plea of not guilty is entered. Honorable Kamba, plea of not guilty entered. And then Mr. Kiria,
not guilty.
Oludda oluwabi lugamba nti emisango gino bano baagizza mu makkati g'omwaka gwa 2019 ne 2023 wabula ng'oluvannyuma lw'okuggulwako emisango gino bonna bagyegaanye, ng'oludda oluwabi lutegeezezza ng'okunoonyereza mu musango guno bwe kuli okumpi okuggwa.
On our third prayer, On a Monday is 24th, I beg your pardon. 24th of June. Then our third prayer is that in accordance with section 122 subsection 2 of the MCA,
Section
122 subsection 2 of the MCA, that the accused persons be remanded for 14 clear days, and court has the discretion to guide us on the hearing date. We so pray, Your Worship.
nga tebannaba kuggulwako misango gino, omubaka Paul akamba asoose kusindikibwa mu kkooti enkulu okutandika okuwozesebwa ku musango ogumuvunaanibwa ogw'okulya enguzi.
Your Honor, in terms of Rule 8, Sub-Rule 3, of the case management rules of this court, the documents are available and we are ready to disclose. But if we had known that our brother has instructions to conduct the trial, we would have even done it earlier. So we are going to sit with our brother and do the disclosure.
So sorry for that. In respect to the submission by counsel for the accused and that by the prosecution, in regard to bail, this court takes note that it granted bail to A2 before the prosecution communicated to it their position to have accused persons committed for their trial by the High Court. A3, as it stands now, A1 and A3 were committed before grant of bail and now have to apply for bail before the High Court if they so wish. Considering the twist in the events, it would only be right and prudent for this court at this stage to cancel the bail that it granted A2 before his committal. Before his committal, so he can equally apply for bail before the High Court. So that High Court that will handle this matter can then handle the bail aspect of the same for all three accused persons when they apply. A2's bail is cancelled in accordance with Rule 20, Sub-Rule 2C of the High Court Anti-Corruption Case Management Rules. In the premises, this court hereby orders that the bail deposit of 13 million that A2 made be refunded to him. A2 is remanded to appear in a session convenient to the High Court, that is ACD, Anti-Corruption Division of the High Court.
Omubaka Paul Kamba asindikiddwa mu kkooti enkulu nga gye buvuddeko kkooti y'emu yasindika omubaka Yusufu Mutembule wamu n'omubaka Sise Namuju mu kkooti y'emu okutandika okuwozesebwa ku misango egibavunaanwa. Wadde nga Principal Cooperative Officer wa Ministry y'ebyobusuubuzi wamu n'amakolero Kavundira Leonard talabiseeko mu kkooti ono waakuggulwako omusango gwa kubulankanya bwombi busatu mu obukadde 448. Bannamateeka bavunaana nga bakulembeddwa Mwesigwa Lukuutana basabye kkooti okubawaayo obudde okusobola okwetegeka nga mw'otulola kkooti olujjayo bajja okusabira abantu baabwe okuteebwa kakalu ka kkooti.
Emitendera gya kkooti bwe wakuwaabira olina kuyita mu mitendera egyo steps zino tubadde tulina ebbeetu okusaba okuyimirirwa naye lwakuba tubadde tetunayogera ne client waffe twasazeewo ne tukkirizaganya ne client tukajira beera eyo tulyoke tutegeere emisango giri kuki kigamba ki kubanga charges olabe naffe tuzirabidde wano tulinda kye tuyita disclosure tulyoke tutegeere omusango gufaanana ki tulyoke tusabe okuyimirirwa twetegeke okuwulira omusango n'olwekyo ekibaddewo kya bulijjo egyo gye mitendera gy'amateeka tekirina kizibu kyonna.
Your Worship, similarly, we did not have also time to interact with A2. We did not know, and A2 did not know the charges which are going to be preferred against him. We did not know when he was going to be produced, and we did not even know the charges, how many charges were there or are going to be preferred against him. As an office of this court, Your Worship, we think it's in order for the state to come up with charges against accused persons and prefer them as opposed to piecemeal charges leading to mental torture and harassment of suspects who are Ugandans. But nevertheless, with the same boat like A1, we are deferring our bail application. We've not forfeited that right to apply. So when we come to knock at your doors, Your Worship, we hope you'll accommodate us. Much obliged, Your Worship.
He has been in custody of the prosecution since the 14th day of June 2024 from 5:13 p.m. It is until today, since 14th June 2024, 5:12 p.m. We've been looking for him, and we were surprised today at 2 p.m. to see him in court in the same attires in which he wore on 14th when he was granted bail. We have not got time to confer with him regarding this matter as far as bail application is concerned. As we are shocked by the charges, as he's equally recovering from the mental shock of the 6 days of being in communicado. So we join our colleague to defer the application until such a time when we are fully instructed by Honorable Kamoko.
Has submitted to the effect that prosecution is bringing piecemeal charges against his client. The simple response, Your Honor, is preferring and management of criminal cases in this country is a preserve of the DPP, and therefore there can be no question whatsoever as to why these charges are being pressed. The principles are very clear. We follow the Constitution and other factors regarding when to separate the charges and the decision to prosecute. Therefore, we wish to respond that there is no harassment intended on his client. The DPP is only following the Constitution, and we are ready to adduce evidence to prove our charges. Regarding the submission of Counsel Robert Mackey to the effect that his client has been held incommunicado, this is altogether different case file with a different charge sheet, and therefore we don't know anything regarding his client being held incommunicado. Now we are committed to disclose our evidence to the defense team and the accused, as it is the requirement of the law. Also from their submission, they concede to my prayer that their clients be remanded as by law, at least for 14 clear days. It's not within my mandate to comment about their bail. We so pray, Your
Worship, we appreciate and acknowledge that under Article 120 of the Constitution of the Republic of Uganda, these powers are with the DPP to prosecute and to manage criminal processes. But Your Worship, Clause 5 is very specific, and for avoidance of doubt, it says that in exercising his or her powers under the article, the Director of Public Prosecutions shall have regard to the public interest, the interest of the administration of justice, and the need to prevent abuse of legal process. Yes, Article 120, Clause 5. And I think it's the interest of the broader, it's in the interest of broader justice, which under Article 126 is supposed to be in the name of the people. So there's nothing more like abuse of the legal process when on the same facts or series of facts you bring piecemeal charges. But some of these things are also for all of us to learn. And it avoids nasty scenarios outside this gate.
Counsel.
All the same,
Counsel,
we do not know.
are you trying to inform court that there are more charges coming on?
No, but you see, the court could have taken judicial notice of a member of parliament who is not my client being released on bail and being arrested. I mean, these people are in their hands. You bring the rest of things.
Piecemeal.
Piecemeal. Yeah, you see, you know, you have these charges against somebody, 1, 2, 3. You wait. Akamba, who is not my client, is released on bail, you arrest. We should do constitutional things when we are also invoking the Constitution. The DPP has all the constitutional powers. But let's also do Constitution. The Constitution does not say detain a man incommunicado for 6 days. No. Anyway, all the same, we would just want to be on the record, for the record, on record. Lastly, Council, the Chief State Attorney has emphasized the 14 clear days. Not once but twice. We do not know what those instructions are, but if it's convenient to court, we have no objection to that. But we reserve the right to apply for bail at an opportune time. We are much obliged. He has told us to give us the disclosures. We'll be expecting them. Much obliged.
Wano mulamuzi Joan Asira ayongezaayo omusango guno okutuusa ng'ennaku z'omwezi mwenda omwezi ogw'omusanvu omwaka gwa 2024.
Have the right to apply for bail, and they choose whether to exercise that right or not. Missions by their counsel, and F4, they are not ready to exercise that right as yet, and court has taken note of the same. For the issue of charges being brought in piecemeal, that's the preserve of the DPP, and the defense counsel who has raised this has not informed this court if there are any other charges to be brought against his client. For A2, whose counsel submits that he was held incommunicado, if A2 feels aggrieved, his counsel knows exactly what steps to take and where to seek legal redress. For the issue in regard to disclosure, the state appears not ready to disclose as yet. The prosecution submits that disclosure will be ready in a month's time, and this would only imply that much as investigations may be complete, disclosure is not ready for this court to fix the matter for hearing. Besides this, since the accused persons are not on bail, matter cannot be fixed after a month, bearing in mind that even if the disclosure is done in a month's time, this court will still have to give the defense time after that 1 month to prepare. Matter will thus be adjourned for mention and not for hearing. At the next sitting, the prosecution will update this court on the status of disclosure. That is when the 4 accused persons return to court. For now, matter is adjourned to be produced in court for plea. We are going to get a date when A1, 2, 3, and 4 will appear for mention.